Hi guys, I hope all of you are doing well. I'm Niladri Mukherjee and I'm a regulated Canadian immigration consultant and I'm the founder and the CEO of Nuvonation Immigration Consulting. The topic of discussions today is that how can you possibly bring your spouse to Canada if your spouse is not otherwise admissible to Canada? So this happens a lot when your spouse has been made inadmissible because of a refugee claim, failed refugee claim. This could also happen because when your spouse was made inadmissible in the past because of any misrepresentation. So we're talking about those kind of issues to how to get rid of this problem and how can you have your spouse possibly bring back to you. Okay. Now, first thing first, you have to understand is that there could potentially be two kind of mechanisms that you would come across through your internet research. Okay, one would be temporary processes and one is possibly a permanent solution. So the temporary processes could range from something like a TRP, which is known as a temporary resident permit, and ARC, which is an authorization to return to Canada. And if you talk about the permanent option, probably you are thinking about something like on a humanitarian and compassionate grounds, spousal or slash conjugal sponsorship application. Okay. 9 out of 10 times when clients come to me for consultation, they tell me that I want to apply for an ARC, I want to apply for a TRP. And again, probably 9 out of 10 times I tell them that, those kind of situations or those kind of applications is probably not the best fit for you because of the strong ties that the spouse has with Canada. So if the partner, if you are a Canadian citizen or a permanent resident, and if you guys have had any child or children together, it is almost impossible to convince IRCC that your spouse will come to Canada, stay with you for temporarily, and then will leave back to his home country, his or her home country, right? It's almost impossible to convince IRCC, and 9 out of 10 times those applications get refused. Okay. A possible logical solution is to go for a spousal sponsorship application under the humanitarian and compassionate grounds. Do not confuse this application with a refugee application or a normal humanitarian compassionate grounds applications. This is a spousal slash common law slash conjugal application depending on the situation, made typically under section 25 under the humanitarian and compassionate grounds. Okay. Generally, people ask me a question about the success rate of those kind of applications, and obviously that is very, very case specific, but generally speaking, regardless of the inadmissibility of the spouse, okay, if that inadmissibility is not due to seditious criminality, if that inadmissibility is not due to section 34, 35 and 37 under the Immigration and Refugee Protection Act of Canada, these applications, and if the sponsor is a Canadian citizen, and obviously a sponsor could be a Canadian permanent resident as well, but the bar is quite high for IRCC to refuse an application if the sponsor is a Canadian citizen. These applications have some kind of merits, okay? And therefore, if you are choosing between a temporary residency application and a permanent residency application of your spouse, please consider this fundamental fact that the factors which are acting as negative for you not to lodge a ARC or a TRP application, that factor or those factors could potentially act as one of those positive factors for you to proceed with the spousal sponsorship under the humanitarian and compassionate grounds. Couple of, I would say, aspects or angles of these kind of applications that you should ideally keep in mind. Number one, these are generally time-consuming application, right? So the IRCC will take its time to do its due diligence and grant you a decision. The decision could be positive or negative, but regardless of the outcome, IRCC will take its own sweet time. And the timeline that we are talking about, if I put an average about from all across the world, because I do work with these kind of applications quite a bit, is about 1 year to about 14 months, give or take, right? That's the one that you're looking for. I would not request you in most possible circumstances to do a lot of travel from outside Canada, from inside Canada to outside Canada while these kind of applications are going on. Okay, that sometimes negatively jeopardizes an application. You do not necessarily need to have a lot of funds, a lot of money, etc. to be able to prove your financial soundness, but you would be in a position to take an undertaking to confirm that you can take care of your spouse when he or she is inside Canada. There has to be solid relationship proof of bonding. There has to be mental, physical, financial, emotional interdependencies that need to be displayed through proper documentation. A proper legal submission letter needs to be gone through the representative, if you're working with a representative, to ensure that the case becomes a watertight case. After you submit this kind of applications, please give IHCC its required time to do the processing before you follow up. 90% of the times, if not 95% or 99%, my advice is not to follow up with IHCC at every 15 days or 1 month time. This is a time consuming application. Give them the time, they will come back to you with the decision. My experience tells me that well-made applications typically get a decision within 1 year window, which is not too bad if you look at the other program-specific timelines in mind, right? So this is one of the logical options that you can potentially think of if you are a Canadian citizen or a permanent resident and your spouse is inadmissible. And if you remember at the beginning of the video, I mentioned that at TRP and ARC, those kind of applications do not work, at least 90% of the cases. 10% of the cases, those applications have worked. Okay, now these are very, very, very situational, very, very, very case specific. It's almost impossible to talk about those without a consultation, but the success rate of temporary applications may not be very high when the spouse is not admissible to Canada. Okay, so this is a summary of it. We as an organization, we deal with this kind of applications a lot. If you need our professional assistance, more than welcome to hop into our website, nuvonation.ca, book a relevant professional consultation. I'll be very happy to have a case-specific discussion with you and go from there. Hope this helps. Bye now.